Judicial, Shri Sudhir Shirgaonkar, to present a potted plant to Senior Advocate Shri Goan Reporter.
Send Modi होना ना.
I would now request Member Secretary Ms. Shabnam Sheikh to present a potted plant to Ms. Anarkali Agni, Senior Advocate practicing at the High Court of Bombay at Goa. I would now request Deputy Registrar Shri Shanur Audi to present potted plant to Ms. Nia Shirgaonkar, Advocate practicing at the High Court of Bombay at Goa. I'm sorry, it's Nia Shirgaonkar. With that, I would like to invite the Member Secretary of the Goa State Legal Services Authority, Ms. Shabnam Sheikh, to deliver the welcome address.
Honorable Justice Valmiki Menezes, Chairperson of High Court Legal Service Committee, President of High Court Bar Association, Senior Advocate Zilman Goel Pereira, Keynote Speaker Senior Advocate Anarkali Agni, Advocate Neha Shirodkar, Senior Advocates, other advocates, and all participants. On behalf of Goa State Legal Services Authority, I extend a very warm welcome to all present here for today's program on sexual harassment of women at workplace, in short POSH Act. We are deeply honored to have you with us, and your presence adds great value to this program. Access to justice is a cornerstone of rule of law. It empowers individuals, including women in the workforce, to have their voices heard, exercise their right, and challenge any form of discrimination or harassment. Access to justice is not limited to court-based legal remedies. It extends to raising awareness and educating both employees and employers about their entitlement and responsibility under various laws, including POSH Act. There is a great movement all over the world to preserve and enhance the sanctity of the workplace and to provide a secure working environment to all. Article 11 of the Convention of Elimination of All Forms of Discrimination, to which India is a party, requires state parties to take all appropriate measures to eliminate discrimination against women in the field of employment. India's commitment to protection and promotion of women's constitutional rights, as well as respect for its obligation under various international treaties, is unequivocal. The Supreme Court of India, in the landmark ruling in the case of Vishaka and others versus State of Rajasthan and others, also reaffirmed that sexual harassment at workplace is a form of discrimination against women and recognized that it violates the constitutional right to equality, and laid down guidelines to address this issue pending the enactment of suitable legislation. Considering the necessity of having a comprehensive legislation to provide for safe, secure, and enabling environment to every woman, irrespective of her age or employment status, free from all forms of sexual harassment, the POSH Act was enacted on 24th of April 2013. The detailed exposition on the topic will be given by Senior Advocate Mrs. Anarkali Agni, and I am sure it will be a very informative and it will benefit all of us. And we have yet another speaker, Nia Shirodkar, who will be presenting the PowerPoint presentation on this topic, which will further add to this subject. I once again welcome all of us, all present here. Thank you.
Thank you, ma'am, for your inspiring words. Your address has set stage for a day full of knowledge and valuable discussions. Next, we are honored to have Honorable Shri Justice Valmiki Menezes, Judge of the High Court of Bombay at Goa, and Chairperson of the High Court Legal Services Committee, who will deliver the inaugural address. Sir, we are eager to hear you. I would request your Lordship to address the gathering.
Senior Advocate, Mrs. Dean, Neha, and all those gathered here. First of all, on behalf of the GSLA, we are really happy to see the numbers. We have taken pains to invite members of the audience from other departments as well. The whole idea is to address the issue of sexual harassment, to take the message back to your departments, back to your workplaces. I know the topic makes many people uncomfortable. There would be many members of the audience who would have a feeling of discomfort because this is a topic that needs to be discussed. It is a topic that needs to be addressed. And though the Act dates back to 2013, we would be lying if we said all is well. So the whole idea is to address the topic aggressively. We have chosen today two speakers. They are senior advocate and a young advocate from our bar, both women. The purpose of doing this was not just to educate ourselves, but perhaps we will share some of their experiences on the field in terms of dealing with cases or dealing with issues of sexual harassment. The Act, as we see it in courts today, has very limited address, and the whole idea of pushing through this effort through the Legal Services Authority is to perhaps help in educating people about their rights under the Act, the manner in which they can have redress to a grievance, to better understand the mechanism under the Act, and most of all, if there is place for improvement in how the Act works on the field, that is something we could address. It is only when we have seminars and interactions of this sort that we also get feedback, and we hope to address issues which thus far have not been addressed. So I won't take much more time. We are all eager to listen to our speakers, and we hope to have feedback from the audience as well after the program, after the interaction. Thank you.
Thank you, sir, for your thought-provoking address. Your words will have provided us with a solid foundation for today's discussion. We now proceed with the first session of the day on the impact of sexual harassment at workplace and gender equality. Our speaker, Mrs. Anarkali Agni, is a senior advocate who will lead this session. She was designated a senior counsel in September 2013. She has dealt with several matters in civil court and the High Court pertaining to service matters, admission of students, habeas corpus petitions, civil as well as criminal matters, matrimonial petitions, and has acted as an arbitrator as well. Her extensive experience and expertise will shed light on this very important topic. I welcome Mrs. Anarkali. Please address the gathering.
My friend, Senior Advocate and my friend, Mr. Desai. 21st of this August debut. Sexual harassment at workplace. A very important topic. And in fact, while Justice Valmiki was speaking, he said that we can also contribute in the manner we had experience in the field while dealing. My score is only number 3. Three cases I dealt with, but that is also from the side of the employer. We did not have a chance to deal with the other side, where the accused or the person who was delinquent officer was the petition on his side. Now, sexual harassment at workplace is really not a new phenomenon. Not today's phenomenon, not a phenomena which is limited to India. It is really a disease. It's a terminal ailment like cancer, which slowly but steadily leads to degeneration of the society. Now, sexual harassment at workplace undermines, strikes at the constitutional right of equality, right to live with dignity, right to practice your profession, practice your trade, right to work. Facing such harassment may lead to diverse problems, some physical, some mental, and which have got direct effect on the work culture, of the work environment, and which in turn will affect the society at large. Now, facing such sort of sexual harassment, as I said, may due to health issues, such as, for example, some persons facing such sexual harassment may have headaches, may have had sleepless night, lack of appetite. So therefore, your work suffers, quality of your work suffers, quality of work suffers on the part of the one female may result in, it has a cascading effect. It will have cascading effect on the other females who may feel that today she is in the picture, tomorrow I may be in the picture. And then as a result of it, it's not a very good reputation for the organization. Because all this happens, nobody reports it because one feels fear. Do I report it? Will it be treated as trivial? Will anybody take note of it? And all such questions. Will I be ostracized? Will my friends look down upon me? Will my family support me? Will my friends support me? Will I be in a corner, staying there like a wounded animal, licking my own wounds? So all these questions come in the mind of the person facing such type of sexual harassment at workplace. And as I said, it leads to mental trauma, it leads to grave effect on the physical and psychological integrity. And the sad part of it is, we are able to note only the tip of the glacier. 90% of it is hidden beneath the surface of fear of, as I said, social stigma. A young girls who suffer it may feel, why should I disclose it? My matrimonial prospects may suffer. Somebody may say, I will lose job if the person who does such type of act is a person in power. Then maybe some action may be taken. I will lose my job prospect. I may not get promotion, and then I may lose my job itself. So should I be or not to be? Should I or should I not disclose? All these questions come to the mind, and one has got a tendency, the people around you, they will concentrate sometimes, not look at the victim in the eye as it is said, but they will look at the facts surrounding. So it's a matter for a juicy gossip. So that also puts the person in fear, should I or should I not disclose? Now Shakespeare once said that women fall when men fail. Now this was of course in a different context, but however it is in the context of the topic we are discussing. When men fail, when men fail to adhere to, remain within their boundaries, so women fall because they have to face all such type of unwarranted acts, which results in, as I said, degeneration of society. Because before that happens, the effect, adverse effect, the trauma, the mental trauma, the physical effect, it is just it destroys the very personality and the very mind of the victim that I did not emphasize before you. Now, in fact, why does this happen? It doesn't just happen because you are interested in perhaps having sex or making sexual advances. That's one aspect. Of course, it's a very important aspect for those who perform it. But then the whole thing is that you are a power point. You are at the focal point of the power. And you think that there are vulnerable persons there who are under me. I can do anything. I can throw my weight around. I can make such type of actions, and nobody will be there to object to it, because I am omnipotent. I feel that I am a superpower, and therefore I can do whatever I can do, and I can exploit the people, the ladies who are working under me. So therefore, actually, this is a PowerPoint game, and one doesn't think at that time that my action, which are obviously to satisfy your feelings, you don't think of what is the effect of it on the subject of your interest. You don't think of what will be the effect of it in the long run on you yourself. And you also therefore don't think on what is the effect on the work culture, on the work environment. The productivity of your organization will suffer. And this may happen in any field, it may happen in our field, among the lawyers, among the judges and the employees. It can happen in every sort of organization, one cannot know. But it happens more often in fields like media or entertainment field, because the parameters there are different, and one feels that one can take such opportunities. Anyway, it's up to this has got direct and adverse effect on the work employees. And let me add, because while I was thinking on this topic, I remembered of one of the what you usually read. We read religious books from every religion, and then one always reads Ramayana and Mahabharata. So there is an incident of sexual harassment at workplace in Mahabharata. I don't know whether anybody has but because there is a case of when there was a gaming between the Pandavas and the Kauravas. They were doing, they had sort of gaming, and then somebody said that if you lose, then you lose your wife. Then you have to stay in the Vanvas, that is in the jungle, for a period of 12 years, and 1 year it will be you have to remain incognito, under a disguise. That is the time that the Pandavas in incognito went to the kingdom known as Matsya kingdom. That was one King Virat. And in that kingdom, the wife, the queen Draupadi, remained as a Sairandri. Sairandri means the handmaid or the personal maid of the queen. So the queen Sudeshna, the wife of King Virat, the queen Draupadi went as a handmaid to her. The brother of Sudeshna, Kichar, found she was beautiful. So he started harassing her. Sexual harassment at workplace, which ultimately resulted in the death of Kichar, which we are very familiar as Kichapur. But this would be sexual harassment at workplace. Now we know about this through Mahabharata because Sairandri was Draupadi. But there must be thousands of Sairandris like that who must have been sexually assaulted and about whom we do not know anything. So it is therefore, we can say it's a very sad thing, nothing to be proud about, but it has been existing from age-old times. Now, second point is, what are the causes? And what is the direct effect of this on the victim? Now, the causes are, our society is a deeply patriarchal society. So therefore, we make, in our own mind and our own way, we make some sort of division. Is the man's job to go out, to earn, and is the woman's job actually to remain in the house? So if you leave that boundary, you overstep that Lakshman Resha, as they may say, then you have to face it. If you go out, you have to work. Then of course, well, if somebody finds you attractive, somebody finds that you should make sexual advances to you, why not? Because you have stepped out of your area. This is the way the standardized thought or the standardized way of looking at such things, but really it doesn't work, because this is not a point which I have to make, that women in no way are inferior to men. When it comes to mental strength, it is equal, sometimes it will be better also, but the point is, you cannot underrate a woman. You cannot say that you have to conform her to this standard area. That's not possible any longer. And then, this sexual harassment operates at every level. It may, as I said, it may occur in so many spheres, but many times the marginalized the marginalized portion of the society, like say Adivasis, the scheduled castes, the informal workers or the domestic workers have to suffer at the hands of, it's a dynamic position of power which leads to a feeling that I am omnipotent, I can do anything from, and with this I can even suppress the vulnerable elements, that is the women. Maybe in a house when there is a domestic worker, the man of the house may say, oh, she's not domestic worker, I have a right to act in any way. So when my wife is not there, I will spread my wings. This is also one of the thought processes which would arise. And now the effect would be of this. As I said, absenteeism. You may remain absent. If you find that your employer is not, your employer or the nearest employer is not behaving properly, you may remain absent. Then you may have sickness. You may leave the job. You may leave, if it is in a university or college, you may leave your course. You may have, as I said, physical ailments also. So therefore, if a feeling, now this may happen because you have a feeling that there is isolation of mind. You feel that there is a breakdown of your support system. You feel that I may be subjected to such type of unwelcome advances again and again and again. So the quality of your work suffers. You can't concentrate on your work. Therefore, it acts adversely on the women to move ahead to improve their job stature, to get better job prospect, to get promotion, because you are simply not able to work in such hostile environment. Now, there is also a feeling that, well, will my complaint be dismissed as unimportant or baseless? Would there be retaliation on the part of my seniors? And these are the fears, all pervasive fears in the mind of the women. Now, I say so with some knowledge, because I was the member of the ICC constituted by the High Court way back in the year 2014-2015, and that time the chairperson was Justice Anuja Prabhu Desai. She was then. During my period as a member of ICC, not one complaint came. Not one complaint was reported. We were just there for namesake on a wall. There was a pamphlet put saying that this is the ICC and these are the members. We looked at it and said, oh, there is the ICC of which I am a member. But I never was made aware that I am a member of the ICC, because no complaint ever came to me. Now, this could be some of the reasons. Either there are two possibilities. The system is very pure, nothing happens, or second is people are very frightened to come forth and say that, okay, I am the sufferer and I have sexual harassment has been suffered by me. So, the one more thing which has to be seen is the digital sexual harassment. Now, digital, with the advent of science, it may be a plus point also. You may send messages and tell the perpetrator of the crime, be aware, we can expose you. This is a plus point, positive. But it has led to like sending obscene pictures, morphing somebody's face, body of someone and face of someone, then sending obscene messages, stalking, wiring, all these things happen. Stalking or using the digital platform for communicating lewd remarks, bullying, morphing the photographs of your women face. This is completely possible. This happens. This happens in colleges, universities, and it can happen everywhere. I know of one such case. This really shows the sick, active sick minds. Active sick minds, those who have a sense of pseudo-superiority complex, they think that it is their birthright to indulge into such type of heinous acts. And as I was telling, there was a teacher, a professor, who indulged in such acts. Messages were written with all obscene references, shocking references to one girl student. Then, in a place where transmission of knowledge takes place, it's a very temple of knowledge, as we say, holy place actually. But such type of acts are done there, where there was physical interference with the students on the part of the concerned professor. Unwanted messages were sent. You may have a very, you may feel that you are very loving nature. You want to distribute love. But why should it be very subjective? That it is limited to only your girl students. That can't be a proper set of mind or proper temperament for anybody for that matter. So therefore, how do we deal with this? Because I'll be reading to you certain judgments also, because you should know how the law developed in this regard. And when it is required that you take regular surveys so as to arrest and eradicate such incidents, you must have educated training for spreading awareness of women-centric rights. They should know what they have, what can they do, and you must have discussions where even such with regard to what could befall such perpetrators of the crime of such people who perpetrate such misdeeds. It's very relevant, very relevant that there must be training session for the ICC, because I am going to, in short while, I am going to tell you of a case where there was material on record. There was a disciplinary action taken by the disciplinary authority, but unfortunately, because the ICC did not go by the procedure as contemplated in the CCA rules, which are applicable to even the teaching faculty, the matter has to be remanded. The orders of the disciplinary authority has to be set aside. Everything was done. Videographing was done, statements were recorded, but what was not done was recording the proper manner and in conformity with what is mentioned in the CCA rules. Now, I will first take you to, I'll just show you the judgment in Vishaka case. Because this is the base. This is the base on which the entire foundation of the action being taken in such matters arises. Now, in Vishaka case, it was said that this was a petition filed by the NGOs. It was a case of brutal rape on Gauri Devi, who was, of course, mentioned here in a village in Rajasthan. And with regard to that, the petition was filed under Article 14, 19 and 21 of the Constitution. And it is said that we must focus the attention on the societal aberration, assisting in the finding suitable methods for realization of the true concept of gender equality. Now we talk about Article 14, we talk about Article 15, which is quoted in the judgment also. There shall not be any discrimination on the ground of sex, but it happens. As Justice Menezes rightly said, we have come a long way from Vishakha judgment. From Vishakha judgment till 2013 Posh Act, how many years has passed? 3 plus 12, 15. And after the Posh Act, we are after 13 years hence. But then, can we really emphatically say, looking at ourselves in the mirror, that yes, there is complete eradication of sexual harassment at workplace? Answer to that is no. Because it happens and happens and happens. There was one case of one sweeper in Goa University who was sexually abused by her supervisor, and she complained, and there was of course the ICC took it up, recorded the evidence through videography. Entire opportunity was given as provided under the Article 40, and when the matter came here in our High Court, the decision of the disciplinary authority was of course upheld some years back. So therefore it is really then you feel warm at heart that yes, you have taken appropriate steps against a wrongdoer, against a thorn in the flesh which is taken out and thrown. So therefore, coming back to the Vishakha case, it was highlighted that every incident of sexual harassment is in violation of the fundamental rights of gender equality, right of life and right of life and liberty. Then conventions, international conventions were referred to, and for the first time, all these procedures, what is the definition of a sexual harassment? That was spelled out, like physical contact, advances, demand or request for sexual favor, which we are more than aware of, like showing pornography, unwelcome physical, verbal or non-verbal conduct of sexual nature, all this. And there was, for the first time, what are the preventive steps, as Madam Shabnam said, that awareness is very important. That is, in fact, according to me, more important than what happens after the incident. When you set up the ICC and it goes before it, awareness should be there. And then preventive steps are more, very much more important, which is spelled out in the judgment. Criminal proceedings, which may be taken. Disciplinary action, which is very important. It also acts as a deterrent factor because you may lose your job if you do all this type of activities. And then the section, provision is going to the complaint mechanism, complaint committee, etc. Immediately following that was another judgment in the case of apparel. This is a very important judgment because that was a case where Apparel Export Promotion Council, that was a case where there was a girl, a stenotypist, who was not very good at her, had just joined, but she was suddenly taken by her immediate superior, who was also a PA or so, to the director, saying that you have to come to a hotel and do the typing work. She said, I am not very proficient at that, I am just learning. She said, okay, I am taking care of it. He took care in a different way. Now he was taken to the hotel, she was taken to the basement, she would type here, sexual advances were made, physical advances were made, and then she was taken to a lift to go to this floor and that floor where such type of activities, such type of things were done. But when the matter ended up before the court said, all right, yes, it may be that there were attempts, but he was not successful at the attempts. There is no evidence of actual physical act with the perpetrator or a delinquent officer with regard to the girl. So the Supreme Court came heavily on this. It is said that it cannot be like that. You cannot interpret, when you are interpreting the evidence of the delinquent officer, you have to take the entire evidence as a whole. There was one more lately a judgment in November 2023 of an Dilip Paul, which which also takes the same view that you have to be very careful in evaluating the evidence of such persons. You cannot take one straight sentence from there. You cannot be superficial. You have to see that in order to come out and say that I have also suffered sexual harassment, it's not easy. It will not be easy for anyone because of the various multifarious factors which may arise. So therefore, in this particular case, it is said that such type of act, whether you are able to be successful in your intent, is not relevant. That you try to be successful is what is relevant. So therefore, it was said that this is against the moral sections. It will not withstand the test of decency and modesty, and it is projected actually as an unwelcome social advance. Once you make an advance, if that's it, it is sexual harassment at workplace. Therefore, in fact, the April judgment ought not to have come, because in Vishaka it was said unwelcome, even if you make suggestions, vague suggestions, also that is enough to say that it is sexual harassment at workplace. And the court said an analysis of the definition shows that sexual harassment is a form of sex discrimination projected to unwelcome sexual advances, requests for sexual favors, or other verbal or physical conduct with sexual overtones, whether directly or by implication, particularly when submissions to or rejection of such conduct by a female employee was capable of being used for effecting the employment. That is the, you have to highlight it or you have to underline. The employee feels that it's going to have adverse effect on my employment, is going to unreasonably interfere with my work. Therefore, what do? I'm cornered, I'm helpless, I'm suffering. How do I get rid of this? So this, then the Supreme Court also referred to the Manila seminar and held that such type of harassment is incompatible with the dignity and honor of our image and needs to be eliminated, and there shall not be any compromise, no compromise with the violation. That is what the court held. And it was also said that you have to deal with this type of cases with a great sensitivity. Now just before the Posh Act came, and I am not going to make any much reference to it because my next speaker will give me some not very good looks. So I will limit to how, which is the other case in between. This is April Export, and there is the case of Medha Kotwal. Medha Kotwal, I will, and there are two cases. One is Seema Lepcha, and the other is Medha Kotwal. Now, in Medha Kotwal, there was an order in fact passed in the year 2004. This says that the complaint committee, as envisaged by the Supreme Court in the Vishaka case, will be deemed to be an inquiry authority for the purpose of the CCS rules, and the report of the complaint committee shall be deemed to be an inquiry. And in terms of this order, in fact, you need not say that there is a fact-finding committee, which is the IC, and then you have another committee, which will be a committee under Rule 14 of the CCS rules. That was not required. Once you have a IC in place, that does the investigation, that holds, and that itself, at that stage itself, you have to give all the possible chance to the delinquent officer to hold cross-examination. So it is a full-fledged inquiry. This, I am emphasizing this because one of our inquiries was set aside by the Supreme Court, and therefore all those who are in charge of either member of IC or who are in connection with formation of IC, this has to be understood, that the IC, when it holds the disciplinary proceeding with regard to a delinquent officer, it has to comply with all the procedures as laid down in the CCS rules. Complete chance should be given to the delinquent officer. Otherwise, what happens is, you may have a very good case. You bring the charges at home, But because of non-compliance of violations of principles of natural justice, it may be set aside, and the next time you hold the inquiry, there may not be witnesses. So therefore you get one chance. It is one inning match. You cannot have the second inning, to borrow the words of my friend Mr. Desai. There is no second inning. It's one inning and it's all over. Then as far as this Veda Kotwal, several directions were given, and Goa heads here because there was no IC frame at that stage, and no amendments were done in the CCS rules. Standing orders were not done, so there is a specific reference made to Goa that all this was not done. So directions were given in this judgment, and also a reference was made to a SEMA lecture, which is very important. It says that the state government shall make a comprehensive publicity to the notifications order issued in compliance with the guidelines in Vishakha and Methakotwala, because people don't know. People simply don't know what I can do. People do not know, can somebody hear my cry? Can somebody wipe my tears? So therefore this was very important, which of course now it is being done. But to what extent may not be to the fullest extent. Then we come to our judgment, which came from Goa in the case of Aurelian Fernandez versus State of Goa. Now this was a case of a professor who was, articles of charges were framed against him, where he was very kind-hearted, but his kind-heartedness was directed towards only some part of his student faculty, and as a result of which there were allegations of sending such messages, physical advances towards his student, and or in his cabin, in seminars, etc. So the entire procedure was completed. Videography was done. But the point is the IC, because of this judgment which came in Veda Kotwal Lele, which said that IC is the now inquiry committee. But the disciplinary authority also had not actually taken the full import of it. Therefore, they constituted the IC only as a fact-finding committee. And they operated as a fact-finding committee. They of course gave opportunity for cross-examination, which didn't await. But they went on collecting the evidence because there is a set procedure in disciplinary proceeding. You collect your evidence, give it along with the articles of charge. You have your imputation, and then you give full right to the delinquent officer to file his reply. Then the procedure comes of the witnesses, etc., etc. That was not done. So therefore, in Aurelian Fernandez case, the entire decision of the disciplinary authority was set aside. Our High Court had taken a view that in such type of sensitive cases, maybe there may be some sort of, they definitely recorded, our High Court, that yes, they felt at one stage it's a fact finding, but the procedure is given, he is given a chance, and these are very sensitive matters. So therefore, they upheld our decision. But in this case, the court said that when there is violation, and you can't say just because the delinquent officer, all right, we'll watch the procedure as provided in the CCS schedule. That's not possible. But in conclusion, very important, they didn't reinstate the concerned officer. They told us to hold the inquiry de novo through IC, following complying with the principles of natural justice, that is, and by way of epilogue, they give all the directions, because they found that it's disquieting to note that there is serious lapses in the enforcement of the Act. Now, this is a judgment of May 2023, where they say that even after such a long passage of time, and the glaring lacuna has been recently brought to the fore by a national daily newspaper, they had conducted and published a survey of 13 national sport federation, etc. So they give their directions, and the matter is still not over. They are collecting the evidence, etc. from this. And then, as I told you, the decision of the Paul. So therefore, the to sum up, there are judgments, the judiciary has been actively coming out, and in fact, then the POSH Act also came, and the POSH Act has got several provisions which my friend here will of course address you. I know my conflict, I'll not overstep. And what is very heartening to know that the judgments come and there is the change in lockups. Like for example, the 79 case, the Mathura case as we see, where it was a case of a rape on a complainant by the gate constable. And as a result of which the 83 amendment came. Then thereafter the Mukesh case or which led to Nirbhaya amendment. So it's very, very heartening to note. So therefore, even after this Vishakha judgment came the POSH Act. So all this show that after the judgments, the change has occurred in the law, maybe plus or minus as the case may be. Now, I will end by saying, I'll just quote what the American famous lawyer, Anita Hill, says, that we should question and look around to look at the harasser, not at their target. We need to be sure that we can go out and look anyone who is the victim of harassment in the eye and say that you do not have to remain silent anymore. Thank you.
Thank you, ma'am, for that enlightening session. Your insights on sexual harassment and gender equality are not only timely, but crucial for creating safer and more equitable environments in the workplace. Moving forward, our next session will focus on POSH Act, law, mandates and implications, which will be presented by Ms. Neha Shirodkar, advocate practicing in the Bombay High Court at Goa. Ms. Neha Anil Shirodkar has pursued her LLB and LLM in IT. She has been practicing at High Court of Bombay at Goa. She is also amicus curiae in many matters, and presently she is on legal aid panel of Goa State Legal Services Authority. I request Advocate Neha Shirodkar to present her presentation.
I have a short presentation on the Act. I will keep it simple, and if anybody has any questions, you can surely ask. So I think Senior Advocate Madam Anarkali has given a good insight on how this Act came into being, what are the volatile situations which resulted in several changes, and how such a thing such as sexual harassment affects women who come to work at a workplace with much effort. So we've already seen the Vishakha judgment, which first laid down the guidelines, which was then formulated into the Act. So the objective of the Act, which my learned senior counsel has already explained, is to prevent and protect women at workplace, and largely to give them a very secure and a safe working environment, so that they can participate in the building of the economy and in also having independent existence of their own. So the Act is set in place so that if there is any untoward incident towards any woman, then if there is a forum of redressal, there is a grievance redressal forum which is provided. The Act postulates that in order for a woman to claim protection under this Act, the incident of sexual harassment should have taken place at the workplace, and the Act is women-centric. Okay, it is applicable only to the female victims or women and does not necessarily address men. But we will see that even in the Act, men are given certain rights
which we will address as we go ahead with the presentation. Next slide, please. So now the Act defines what is sexual harassment. Under Section 2A, it says sexual harassment includes any one or more of the following unwelcome acts or behaviors, whether directly or indirectly or by implication. So if anybody makes any physical contact and advances, if there is a demand or request for a sexual favor, if somebody makes a very sexually colored remark, or it can also be a joke, a sexually colored joke, showing pornography, or any other unwelcome physical, verbal, non-verbal conduct of a sexual nature. Next slide. Next slide, please. So to sum it up, it's harassment when any kind of sexual favor is requested or asked for in a work setting, in implicit term or condition of employment. Any kind of employment decision. If you are subject to getting a promotion and the person who's senior to you says, I will give you the promotion subject to request of a sexual favor, or if you are subject to any kind of, if you are entitled for increase in pay, and that is also withheld because you did not give in to the sexual favor requested. So any of your job prospects, if they are affected because of this, it constitutes harassment. Also uninvited, unwelcome conduct or behavior, whether physical, verbal, non-verbal, or simply creating an environment which is very uncomfortable to you. Very uncomfortable for an employee. Like ma'am said, once it happens, second time you are scared to go to work. Or some of them may not have the courage, so they may just quit. So such an unfavorable, unwelcome environment is being created, then it can certainly be covered under sexual harassment. Next slide, please. So what some instances, or if I have to encapsulate sexual harassment, it includes sexual propositions, suggestive comments, excessive flattery, questions of a very personal nature which will make you very uncomfortable, repeated unwelcome requests for dates, sexually oriented kidding, teasing, practical jokes, jokes about gender specific traits, offensive or obscene language or gestures, leering, staring, whistling, hooting, offensive or obscene printed materials, pictures, posters, cartoons, and like ma'am said, even using social media or WhatsApp, sending lewd messages across, inappropriate physical conduct or touching of a sexual nature. For example, brushing, patting, hugging, pinching, shoulder rubs, hugging you unnecessarily. All of this will constitute sexual harassment. Next slide, please. So now, this act is specifically for sexual harassment at workplace. So it's very important. What is workplace is defined under the act. So workplace means premises of the organization, all its branch offices, and any place that the employee is asked to visit in lieu of the work given to him. It also includes the transportation used by the employee. Either the employee can go via public transport, or it also includes the transportation provided by the employer. Sometimes you are afforded a car with a driver, and if anything untoward happens in the interaction, that also comes within sexual harassment. We will discuss a case of one X versus Ola in Bangalore, wherein this issue of sexual harassment was raised. I'll come to that case. We also see, it's a small joke that I've put forward. We can also see who's an employer. So an employer means any person responsible for management, supervision or control of workplace. And management includes person or board or committee responsible for formulation, administration of policies of any organization. Next slide, please. Now, when we look at the definition of employee, it's very wide. So, an employee means a person employed at a workplace on regular, temporary, or ad hoc or daily wage basis. It can also be somebody who's employed directly or through an agent. It also includes a contractor with or without the knowledge of the principal employer. It also includes individuals employed, whether for remuneration or not, working on voluntary basis or otherwise, and whether the terms and conditions of employment are express or implied, includes a co-worker, a contract worker, a probationer, a trainee, an apprentice, all called by any such name. So even if an intern who has been given some work or is interning for a month in any department can also be covered herein, even though there is no remuneration paid to that individual. So now coming to the definition of a respondent. Who is a respondent for us as lawyers? Very easy. Respondent is somebody who's opposite us, the party that is opposite to us when we file. Now in this case, it's a word that is used to refer to the individual against whom the concerned female has raised an issue of sexual harassment. So that person against whom the aggrieved woman has made a complaint to the Internal Complaints Committee or to the local committee. So that person in this act is referred to as a respondent. Also defines what is aggrieved woman. It is a woman of any age, whether employed or not, who alleges to have been subjected to any act of sexual harassment by the respondents. So now, if you are subject to sexual harassment, what will you do? You have a forum. Which is your forum? If it's an organization, if your organization has more than 10 employees, then your forum is the Internal Complaints Committee. And this is the composition that your Internal Complaints Committee should have. Now, I'm sure all of you all must have seen this board. Like Madam said, she was also part of the Internal Complaints Committee. And every organization now has two boards that you all see. One is your RTI, if it's a government department, the RTI board. And second is your Internal Complaints Committee, where you have all the members who are part of it, their names are recorded, very much visible in most of the departments. So this constitutes of a presiding officer. You have members, not less than 2 members who should be a part, and 1 external member who should be a member of an NGO who has some experience in working with women-related issues. So, say your organization has less than 10 workers, or next slide, please. Just a cartoon, yes. So, what to do if one feels sexually harassed? If anybody, you or anybody you know, feels sexually harassed, then she shall file a complaint with your Internal Complaints Committee if there are more than 10 employees. And in case of series of incidents, the complaint can be filed within 90 days from the last day of incident. So it can